Hi everyone, this is Veronica. Today our topic of discussion is decriminalizing beggary. So that is a blow against punitive constitutionalism. So we'll discuss this decriminalizing process of Beggary Act in detail. For video updates, you can connect with me on Instagram and Facebook because I feel together we can make a difference. So now what is the relevance of this topic in your exams? It will be covered in your mains paper 2, Indian Constitution, historical underpinnings, evolution, features, amendments, etc. So at prelims level, you should be well aware with the provisions of the Act, and mains level, the analysis of Beggary Act is very important. So in what context today we are studying this? See, firstly, recently in a landmark verdict, the Jammu and Kashmir High Court struck down the J&K law on beggary. Then see, this Beggary Laws in India is a relic of old colonial legacy. For example, according to Criminal Tribes Act 1871, if you read this, the indigenous people, the tribal people, they are deemed criminals. So this law said they are deemed criminals by birth. So this is how shitty this law is, and herded into concentration camps earlier, where families were separated and forced labor was the norm. Now there are many laws, example of such laws. For example, you look at the criminal tribes, this colonial legacy I'm talking about, look at this Criminal Tribes Act. So this is what I told you, that indigenous people were deemed criminals. And post-independence, despite independence and adoption of constitution, post-colonial Indian state replicated many of the worst excesses of the British regime. Then you look at this Beggary law that I am talking today. It was enacted in Bombay in 1958 and later extended to many states and union territories. These laws criminalize itinerant and nomadic communities, anyone who does not fit in the state's definition of normal citizen. So they establish a system of certified institutions that are little better than detention centers. So these certified institutions, you should know, they are not better than even the detention centers. They facilitate the continued stigmatization of some of the most vulnerable and marginalized segments of the society. And therefore this recent judgment comes into play. Jammu Kashmir High Court, it struck down this Beggary Act, and it identified the colonial origins of the law and found it to be gross violation of human dignity, equality and freedom. So let's see, here we'll talk about these Beggary laws. First, what is the broad definition of begging? So begging is defined as having no visible means of subsistence and wandering about or remaining in any public place in such condition or manner as it makes it likely that the person doing so exists by soliciting or receiving alms. Okay, so this is what the beggars do. So that is where this definition comes into play. Then look at beyond begging things, because Beggary laws goes substantially beyond criminalizing the act of begging. They criminalize people who are wandering about and who look like they might need to beg at some point of the time in future maybe. Then the purpose. The purpose of such provisions is not to protect public peace or prevent crimes, but to effectively cleanse. So what they say? We are cleaning the society. So they say cleanse. So we'll cleanse the society, these spaces of individuals who appear poor or destitute. Then the process. People found begging, they can be arrested without a warrant and thrown into beggars' homes for a year or 3. That is what have been done. And then the Jammu Kashmir Prevention Beggary Rules authorized forced medical examinations on the beggars. So these beggars, they were forced because of some medical examination were taken on their bodies, they were taken into police custody, shaving of hair and removal of clothing in order to undertake the phrased cleansing of the body. That is very, very bad. And then what is the government defense for this? The government defended the law on the ground that it was necessary to make good citizens out of beggars, and that is why necessary to maintain public order. So this is the government defense, that they are making from the poor people, they are making them good citizens. By doing such kind of things to them, they are making them good citizens, and in order to maintain the public order. That is totally absurd. So here we'll do the analysis of the judgment. Firstly, origin of such statutes. As I told you, under the belief that people without settled means of sustenance were a threat to society, a number of such statutes were enacted and served as precursors to the Beggary laws. Then if we look at it in India, begging was first criminalized in 1920s to subjugate certain communities by imputing criminality to them. So what does this begging indicates? You can tell me in the comment box, what do you think, how the begging starts, what it indicates? See, begging and homelessness is indicators of abject, I will write here, they are the indicators of abject and chronic poverty. That chronic poverty means that not from the one generation, such families have been suffering from poverty from ages, from generation. That is chronic poverty. So poverty had social causes. Beggary is a manifestation of the fact that person has fallen through the socially created net. And poverty, it does not belong to one individual. Individuals have not created it. The court rejected the view according to which poverty is a consequences of individual failings, because the defense, they were saying that because an individual fails in life and that is why poverty happens, but it is not a individual thing, it is a social thing, it is a economical thing. Then talking about the fundamental rights, begging was a peaceful method by which a person sought to communicate their situation to another and solicit their assistance. So it was protected under Article 19(1)(a), right? So it is protected under this, and that is the freedom of speech guarantee. And here why I have written no proof. See, the government failed to demonstrate how beggars into homes would transform into good citizens, because the government in their defense, they said that we are making good citizens out of these poor people, but there is no such proof. How you can make them good citizens? What is the definition of good citizen? What is the proof that they are not the good citizens, right? And public spaces access, look at this point. See, by criminalizing wandering about, because beggars, so we in this acts wandering, if they are wandering about, this was also criminalized. So if you are criminalizing wandering about in public spaces, the law attempted to exclude the poor and the marginalized from places that were meant for the enjoyment of every member of the public without exception. So it also violated constitutional guarantee of freedom of movement. Now you understand that if there is a park, for example, all the people can go there, but the beggars are not allowed. Why? Where is their freedom of movement? Because it was prohibited by such laws. Wandering about was criminalized. And next is nature of existence. See, a large number of itinerant communities, such as there are Gujars and Bakarwals in Jammu Kashmir, whose very nature of existence is moving from place to place. This would bring them within the ambit of beggary law. So if we talk about dignity, by effectively criminalizing poverty, so you are doing nothing in the beggary law, but you were criminalizing the poverty. If being poor is a crime, so the beggary law violated basic human dignity. So it is a prejudiced view. The legislation was steeped in prejudice against poverty and premised on an absolute presumption of potential criminality of those faced with choicelessness. So these poor people, they don't have a choice, they have choicelessness, and what we are giving them, we are criminalizing their status. So they have, what we should say, they also have right to life, right? Because coupled with the draconian processes under this act, it violated the right to life and it also violated the personal liberty. So you tell me, okay, personal liberty. So it was being violated by such laws under Article 21 of the constitutions. See, because somewhere we are trying to submerge the individual rights. Recent years we have seen the rise of phenomena known as punitive constitutionalism. So let me write here. Okay, this is written here. So this term is on rise. So what is this term? That it seeks to submerge individual rights to a grand and undefined national project. So somewhere we are told this is in nation's interest, so your rights will be submerged. So it says that an individual may be stripped of their rights if they do not do their bit to contribute to this project. So the laws barring political participation to those who have more than 2 children or who lack formal education effectively make freedom and equality very, very conditional upon the state's vision. So here it depends upon the state. What is their definition of good citizen, right? So this is what is punitive constitutionalism. So rights are no longer about being human. So this is very important. Listen to this line, that rights, I have written here, rights are no longer about being human, but about earning the right to be treated as human. So this is the state in present days, right? So the Beggary Laws along within the same family of punitive constitutionalism. So to conclude here, we should say that Jammu Kashmir High Court judgment is explicitly premised upon the unconstitutionality of invisibilizing a social problem. So social problem is poverty, and the government, the law was criminalizing it. Thus it shows us the exact way in which our constitution rejects such harsh world view, right? So we could have in alternatives also. Here I would like to mention a Bihar model. Okay, as I told you, there in the centers presently that were there, they were no less than the detention centers, but there's this Bihar model. The Bihar government has Mukhyamantri Bhiksha Vritti Nivaran Yojana. I will write it here. Mukhyamantri Bhiksha Vritti VRITI Nivaran Yojana. Okay, so this is in place. Under this, instead of detaining persons under the Act, open homes were set up. Through this, community outreach for destitute persons was put in place, and now rehabilitation centers have been set up with facilities for treatment, family reintegration. So there is treatment being provided to them, family reintegration is in process, and along with it, vocational training is also given to the people. So this is very important model. You can quote it while you write the answers in the exam. So this was all about today's lecture. Even if you know, in August 2018, Delhi High Court has also decriminalized beggary. Right, the Delhi High Court has decriminalized beggary by striking down Delhi Prevention of Begging Rules 1960, which were formulated under Bombay Prevention of Begging Act 1959 as unconstitutional. That time also the court has held that the Begging Act violated your Article 14 and Article 21. Article 14 is your equality before law. Article 21 is your right to life and personal liberty. So that is why the court noted that the definition of begging under the Act was very, very arbitrary. So this was all about today's lecture. Thank you. So this is the channel StudyIQ. If you're preparing for UPSC or any government exam, our pen drive and tablet courses are available. If you're preparing for UPSC CSE 2020, our pen drive course is available, where you can find 100% coverage of UPSC vast syllabus. Daily current affair updates will be available. Self-paced learning process is provided. This course has been prepared by top faculties of StudyIQ, and now you can purchase this course at Rs 625 per month only. For additional information, you can visit our site, and there are the phone numbers also given. You can call them and gain the additional information. You can connect with me for my video updates on Instagram and Facebook, because I feel together we can make a huge difference. For queries, you can even email me. Thank you so much.